Will your Nevada lawsuit get sent to the arbitration program? Hi, I'm Tom Friedman. I'm a lawyer in Nevada, and there are certain exceptions, but almost all civil cases with a value of less than $50,000 are going to go through the arbitration program. Now, the cases that are automatically exempted from the arbitration program, it's a short list, includes probate, divorce, title to real estate, class actions, medical malpractice, and declaratory relief actions. So if you have a typical personal injury type case, the value is presumably less than $50,000, you're going to be in the arbitration program. Now, let's say you've got a case that is in the arbitration program and you believe the value of it is more than $50,000, what you need to do is promptly file with the court a petition or a request to exempt the case from arbitration. And the way you do that is you prepare your document and you explain why it is that you believe your case is worth more than $50,000. If it's a personal injury type claim, you're probably going to want to put the medical bills in there and say, hey, look, I've got all these medical bills, therefore it's probably worth more than $50,000 and it should be exempted. And then the proceeding judge is going to say yes or no. And so yes puts you into the normal trial track with a jury and judge and everything else. No keeps you in front of the arbitration in the arbitration track, so your case is going to get arbitrated, but there is something you can do at the end. So let's say you've got this case, it's staying in the arbitration track. What happens? Well, next you get sent out a list of potential arbitrators on it. If there's two parties, then each party will get to strike two of the arbitrators, and then whoever's left is going to be the arbitrator for your arbitration. The arbitrator is generally a lawyer that works in Nevada. It's not necessarily a judge or some specific type of person. So what'll happen is you'll meet with the arbitrator probably over the phone. You're going to have this hearing where both parties say, hey, this is kind of what the case is about. This is what we need to get done. The arbitrator is going to set a date for the arbitration hearing, and based on that date, kind of work backwards and come up with the discovery dates. And what that means is you're going to get some limited discovery. You're going to get to send written questions, interrogatories, requests for production, whatever it may be, to the other side. You're going to get some limited depositions. And so you're going to have sort of this compressed discovery phase compared to what it would be if you were in trial. And the reason for this is the whole concept of arbitrations is to sort of make things efficient, not cost a lot of money, and so you get this abbreviated discovery period, and then assuming the case doesn't settle, you go have an arbitration hearing. And the difference between an arbitration hearing and trial is almost night and day. In the arbitration hearing, you're going to have the lawyers for each side, or if you don't have a lawyer, you'll be there without one. You'll have the parties to the case and maybe any witnesses, and you're going to have an arbitrator. It's probably going to take place in somebody's office. There's no judge, there's no jury, there's no bailiff, no policeman, nothing like that. You're just going to be sitting in an office. You're going to have the arbitrator at one end of the table and the different parties on either sides of the table. And assuming both sides have a lawyer, the lawyers will prepare what's called an arbitration pre-hearing statement, basically a summary of the case. They're going to attach the evidence, the documents. The arbitrator is going to read all of this beforehand. So you're probably not going to have wonderful opening statements. You're probably just going to get into the meat of it. You're going to have the witnesses testify. The arbitrator is going to make a decision based on all the evidence. The arbitrator might give you a written response the very same day. That's pretty unlikely, but usually within a week or so, you're going to get a written decision from the arbitrator. Now, if both sides are okay with that, the case is done, money is exchanged, and or no money if it was a defense verdict, and that's the end of it. If one side is very unhappy with the result, or possibly both, you can appeal from the arbitration track to the trial track. And so in order to do that, the arbitrator's fees have to be paid. You have to timely file your paperwork, but then you can go off onto the trial track afterwards. But you do have to get through the arbitration portion of it first. So if you've got any questions, please feel free to give me a call. Thanks very much for watching.